Okay, well, hello everyone. It's been a minute since we talked. We've missed you, but glad to be back. All right, it's been a little while, so we just wanted to dig into one of our cases and one of our summaries. As you can find them on workerscompensation.com, but you can also find them at Simply Research because, as we've said before, we want to be that one-stop shop. So if you get a Simply Research subscription, you get our featured news there. Our daily headlines go straight to the Simply Research page. So we're going to take a look at a recent case, and then they just live there forever. So we're going to take a look at a recent case that we covered to give it a little bit of a closer look, and hopefully it's an interesting one that we'll be able to learn something from. So we're going to go ahead and share our screen here in just a second. Give me a moment. I'm going to do that. Boom, boom, and click there, and here we go, and there we go. So as always, here's the home page. This is the first thing that you come to. And I'm going to get to this by going to a feature that I've highlighted before, our What's New feature, so you can see what's popped up here over the last few days. Starting with today, we have some information out of California, some rules. Oregon's had quite a bit going up. There's a Utah case up there. Some of these we might be digging into a little bit more in the days to come. So check workerscompensation.com. And of course, if you're on Simply Research, it'll pop up there. So if we do any more summarizations or we take a closer look at some of those rules, as we often do, they'll definitely pop up in the What's New. This goes back a few days, so you can see that every day we're adding to this. Our compliance team is out there scouring for the latest cases, any updates and rules forms right here from Pennsylvania. And, as always, we would like to keep the various forms. So we've got the Spanish language form that Pennsylvania's put together. We cover it all. And we make sure we stay up with the whatever is coming out from the state, so you don't have to go digging around there. We get it for you. And so here it is. So the case was Brown versus Plans Plus. So if you want to just read the case, and not get that, here it is. There's the full text of the decision. This is an appellate division case out of New York. And there it is. So you can read that. Now, if you want to get to the nitty gritty of it, there's our summary. And this just happens to be one that I wrote, but that doesn't mean it's any better or worse than any other one. So here we go. And we've tried to tinker with the format a little bit to bring you the information that you need right there and kind of make it easy for you to understand so that if you don't want to read the case, you don't have to. So this was a case where someone was an office worker and she bent forward in her chair, fell to the floor, and experienced some back injuries. Kind of a unlucky break there. And what the on her claim there, the workers' compensation law judge, denied the request for an extreme hardship redetermination. So there was, everything was kind of cool under the claim, and then eventually she wanted to get an extreme hardship on the basis of her finances. Makes sense. There's a provision under New York law for this. And there it is. So we break it down. That's the rule of law under New York law, where the loss of wage earning capacity is greater than 75%. So in this case, it was 80%. The claimant may request within the year prior to the scheduled exhaustion of indemnity benefits that the board reclassify the claimant to permanent total or total industrial disability. And those are likely defined under the statute. But anyway, now the key here, though, is that extreme hardship isn't defined in New York statute. So the court has to look to other decisions and also looks to legislative history. Now, courts don't typically like to do that, but sometimes they do because it's not binding authority, but it can be persuasive. In this case, it was persuasive. And there was another court decision on this topic about a year ago, also in the app div, that use a definite dictionary definition. Again, that's not binding, but it's highly persuasive because you look and say, okay, well, what does extreme financial hardship mean? So, looking at legislative history, looking to this precedent case, the court here said that the rule of law that they were going to operate under is that to show extreme hardship, a claimant, in this case the worker, must demonstrate financial hardship beyond the ordinary and existing in a very high degree. So it's a pretty high standard. It's going to be a tough one to meet. So they're not just looking at, you're having a hard time paying the bills. It's got to be something that's really beyond what might be considered an ordinary case. So looking to the facts of the case, the court ended up affirming the board's decision. And the court said, well, she really didn't have any unusual or unexpected expenses for a person on a fixed income. So looking at the circumstances, okay, yeah, it's not a great situation when you're on a fixed income, not making the money that maybe you could be making. But what they said is, she needed to do a little bit more than just say, and that this is the point here that I should bring up, that she was saying that her expenses exceeded her income by $300 just about every month. And the court says, well, that by itself, that alone isn't a good enough case to show an extreme hardship. There might be some other facts that she could have presented, but that isn't really going to do it. And as we describe in our Workers' Comp 101 little blurb there, what a board will consider is look to factors like the claimant's assets, monthly household income, monthly expenses, and any other relevant factors. So it's a fairly claimant-friendly situation. If it's relevant, they'll take it into consideration. But in this case, they looked at these factors and said that it didn't really add up. Namely, the worker lived by herself in a 3-bedroom house. And prior to all this, prior to the accident, she took on a $150,000 home equity loan. And in her case here, she didn't really explain where that money went. She had a luxury vehicle that she leased that cost $300 to $400 a month, which isn't a terribly high bill, but could she tip the scales a little bit better in her favor to say that she's in extreme financial hardship by maybe not having a luxury vehicle? Probably. This is what the court is kind of looking at, and then she just said, kind of argued, that she had a credit card payment of $300 to $400 a month. And she was, when pressed for it, she kind of had to say that her Social Security payment after the injury had gone up every month. So the court here just isn't convinced that we're in an extreme situation. Yeah, I mean, she might be having a tough time, and it might very well, they're not questioning her math necessarily. I mean, it might be the case that she is running in the red $300 a month. But looking at these factors, a big house, this money that she hasn't accounted for, a luxury vehicle, she's no documentation about this alleged credit card bill, and then, admitting that her Social Security payments have gone up recently. All of that kind of conspired to get her on this extreme financial hardship question. But we do these, the cases, an example of what we try to do on a regular basis is to bring you something that's an interesting topic, hopefully, and sort of shine a light on it and give you a sense of what the state of the law is in your state or any other state that you might have an interest in. We'd love to hear from you. If there's something that you want us to cover, if there's a topic that you're interested in, that you're curious about, get in touch with me. You can drop me an email at fferrari@workerscompensation.com and let us know what you want to see covered on our site. In the meantime, don't forget that if you're not on Simply Research, you can get yourself a subscription by going to workerscompensation.com and trying it for free for 7 days. It's a great deal. You have nothing to lose. There's no strings attached. We're not going to bomb your email. We're not going to spam you. We're not going to give you calls. We just want you to try the product because we believe in it. And we want you to get in there, see what you're missing, and then perhaps consider signing up. So how do you do that? Well, you go to solutions and you go to Simply Research. And there you go. Just you can get it as low as $99 per month. That's a great deal. You're not going to find that anywhere else. There's other services out there that do an excellent job, not going to lie. But this is a deal. $99 a month for Simply Research is something that, honestly, and I'm not just saying this because I work for the company, it's a little bit of a no-brainer. But anyway, just so you know, you can try it out. You go ahead and, here's our little thing there, and there's the free trial. Go in, sign it up. You'll get your 7-day free trial. So I encourage you to check it out. It could be worth your time. But we also want to thank you for spending your time with us here. Hopefully this has been interesting. Like I said, if there's any state that you want us to cover in more detail, if there's any topic, if there's anything that you're interested in, please get in touch with us. Anyway, until next time, thanks so much, everyone. Have a great day.